Hi, Joanne. At least I see you in there.
Hi.
Okay.
So everybody is going to be me.
That's what I think. So I think I'm going to tell everyone when they log in to rename themselves.
Okay. Yeah. Sorry about that.
I don't know. That's not your fault.
So who's the other Joanne on here?
Good question. Somebody listed as a panelist, so they must have logged in. Oh, I'm not sure. I'm gonna have them unmute.
Uh-oh.
But you didn't log in as a panelist, did you?
No.
Okay. Okay, I think maybe what I'm gonna do is this. I might give you, this might boot you in a second or push you down to attendee. Let's see. That's great. There's me on a beach. Okay, so for all the various Joannes in the chat, can you guys please rename yourselves? We had an issue with the way invitations went out. So everybody's going to be Joanne today until they rename themselves. And I'm going to do this. There we go. I'm going to let everybody, at least these initial 4 people, talk because I'm not sure which one's which.
Okay. I'm Joanne, the real Joanne.
Okay.
The real Joanne, please stand up.
All right, let me mute the other Joannes.
Name.
Hi there. Would you mind renaming yourself in the chat?
I really don't know how to do that.
Oh, I'm sorry. Okay, let me see if I can. Here, do it this way. It's gonna be a real mess. Okay. I need. Okay. Real Joanne again.
Hello.
Hello.
Just an attendee. I don't know why it's showing up differently.
Yeah, that's not your fault. That's on us.
You want me to come back in later?
What I'm going to do is I am just going to rename. If you can rename yourself, or I can rename you.
I didn't get a prompt to do that, so I'm not quite sure what to do.
Gotcha. Okay.
You know, usually it'll ask you to identify yourself, and it didn't do that.
Yeah, we had some tech issues. The invitation that went out to everybody was Joanne's personal invitation, so everybody who logs in is logging in as Joanne.
Well, are they going to send out a new one? I can just join again if they're going to do that.
I don't think so. Our tech person is out sick today, so we had to do a real quick last-minute scramble.
Okay, so Jacob, can you hear me, the real Joanne?
Yes.
Okay, so it really doesn't matter. I don't think that everyone is Joanne as long as Jacob's able to get me to be a host so that I can help him. And then after that will allow everybody to then sign in. for their CLE credits with their real name.
Yeah, I'm sorry that it worked out this way.
Yeah,
Put it
I
that
do
way.
apologize. It makes it more fun this way, right?
Yeah.
Will that be emailed out, or
Yeah.
do we put it in the, it will be for the CLE?
Yes, so if you registered, then you will receive the form later today with directions, and it will tell you how to sign up for your CLE credits.
Thank you.
So super easy. I will make sure everybody gets their credit, regardless of how you're signed in.
Okay. Do this. All right. Now, I don't know if the people who log in next will end up as attendees or panelists, so we might have to do some shuffling as people come in.
Right.
But
I do apologize, Jacob.
that's it's not on you. It's all of us. The miscommunication. Okay. Make sure my presentation's looking good. That's all right. See, there you go. Okay, here's what I'm going to do. I'm going to unpanel, make you not a co-host here for a little bit, real Joanne, and then when the presentation happens, I'll boot you back up.
Hello.
Hello. We are dealing with some technical issues. I did not mean to make you a host. As you'll all probably see, everybody is logging in as Joanne Sprague. We're got some technical issues that just kind of have to fix on the fly here. But once the presentation starts, we will let you know how we're solving this problem. Yeah, I'm trying to think if there's a smart way to do this. Participants. There we go. For those of you logging in, we're having some technical issues. Yeah, people who are logging in everyone was sent out the same link, which is, I think, means everybody's coming in as listed as Joanne Sprague. So those of you who can, if you right click on your name, you can rename yourself in the chat. And I'm going to do my best to rename folks as they come in. Once the presentation starts, I'm hoping that that's not going to be an issue, but we'll just kind of play it by ear. It's the curse of doing this in virtually. Right, I'm going to try and promote just the real Joanne. We're going to see if this helps. I think that this may make things more complicated. Let's see here. And you're back. I don't know what's going to happen as other people continue to log in. So maybe I can add you as a host for a little bit, make you an attendee, and then bring you back in as a host again.
Okay. So yeah, there is another real Joanne on here. It's just Andy Antonio. She's a friend of mine.
Hello. Hello to all the various Joannes.
I'm not such a bad person.
Yeah. Yep. See, everybody gets changed to an changed to a panelist. Oh, what a mess.
You know, it doesn't matter. We're still going to be able to get the content out. I think if everybody just goes to their speaker view, the person that's talking, which will be mostly Jacob and me a little bit, will then be the main frame. And people will get their CLE credits. We have a different way to do that. So it's a little weird, but we can still, it can still be a very effective CLE.
Once I start presenting, it should be okay, because I think I'm the only person who can share my screen, so that'll at least solve that problem. And a couple minutes to trickle in. Thank you, everybody who is attending today. I think this. Do you know how many people are registered as of now?
We have 74 people registered.
Oh, that's good turnout.
Yeah. So thank you to everybody. I'm going to mute for now because my dogs are starting to make noise. So. Yeah.
No guarantees that my cat's not going to jump on my lap halfway through this, but we'll see. Would you like me to start at noon? Should I just start rolling into it and I'll let folks ask questions as we go? Okay, great. And we're going to, I think because of the sort of weird technical issues we're running into, folks, put your questions in the chat. I will try and answer them as they come up throughout the presentation, but I have saved time at the end for a Q&A, and I know that it might be a little complicated with the way this is working out for me to have Joanne ask me questions midway through. But we'll roll with it and see how it goes. And to the person in the chat, no, we can't see you. If you have questions, please put them in the chat box. We will answer them either at the end of the presentation, or I'll probably take a break halfway through it and run through some of the questions that come up during. Normally I would have a tech person who's out sick today, so we're kind of playing this one by ear. But thank you everybody who's attended. Thank you for this, allowing me to do this presentation. Thank you, Joanne, for inviting me to do this presentation. I'm going to share my screen and let's see how this works. All right. Joanne, are you able to see that? Real Joanne?
Yes, I can.
Okay, great. So I'm going to do my presentation. I can see and hear you. So assuming there's no more technical issues, let me know if you see questions, because I can't see the chat box while I'm presenting. Thanks, everyone. My name is Jacob Kuykendall. I'm a staff attorney for the Civil Survival Project. We are a legal aid program as part of the Public Defenders Association that helps people who've been impacted by the justice system with reentry issues. Prior to this, my background was I worked for the King County Bar Association and their reentry legal aid program. So I have, at this point, like 2 or 3 years experience helping people vacate convictions, waive LFOs, basically the stuff that happens to folks when they have something on their background report when they've been through the system in some way. Thank you so much to Joanne and Kitsap Legal Services for inviting me for this. Happy to answer questions, put them in the chat as we go. Sorry for any technical issues that we've run into and any new ones. I've saved time at the end for questions and I've included my contact info. One thing I just wanted to say at the top, both a disclaimer and like a tip. The disclaimer is I'm going to give you kind of my experience doing this work in King County. Things are likely different, especially those of you who are coming from counties outside of like King and Kitsap and Pierce. There may be different things in your particular area. I'll try and call out places where I know procedures can vary. And also, we're in the middle of a pandemic and that has made things very weird in some courts. And I just can't tell you exactly what the procedure is going to be depending on where you are. The other thing I wanted to say is that part of my role here at Civil Survival is to bring the level of knowledge in reentry issues up around the state. So I'm going to include my contact info at the end. If you have any questions about vacating, about any sort of reentry stuff, I'm available to answer those questions. It's part of my mandate, my job. So don't hesitate to reach out if you want resources or information about any of the stuff I've talked about, or even anything that comes up in your work, regardless of how that is. So let's talk about vacating convictions and how those can change people's lives. So I've got a few goals today. I'm going to talk a little bit about vocabulary. This is kind of my, I always introduce my presentations this way, how to talk about these issues. I'm still learning and things are always changing, but if there's one thing you're going to take away from this presentation, even if you're never going to volunteer or do this work, this is really helpful. I'm talking about who needs this work, who you can help, how convictions end up becoming barriers in people's lives. I'm going to talk about what my program is, the Reentry Legal Aid Project, or RLAP, a little bit about the work that we do, the process for vacating convictions, and then ask for volunteers, ask for the help you guys can give to Kitsap Legal Services, and then saving some time for questions and answers at the end. So let's talk about some vocab a little bit. I try and use the term people with convictions. I've given this presentation or presentations like it, I don't know, a dozen times, 2 dozen times now in a variety of different contexts, to attorneys, to service providers, to individuals who want to do this work for their own records. I use the term people with convictions. You will hear, and I've heard a lot of different other terms like felons or convicts or defendants. Offender is one that gets used in the law a lot. I would tell you don't use those terms, and there's 2 reasons. One is it's dehumanizing. Folks who have been impacted by this, they have heard those terms used against them in really negative contexts. If you're volunteering or if you're doing this work, you are going to have a really hard time building rapport with somebody, and they're going to have a hard time trusting you if you use those type of terms. And I also think it's important to point out, most people who've had this experience, if you volunteer, your client has almost certainly had really terrible experiences with lawyers for a long time. They probably had the worst time of their life talking with or working with an attorney. So doing what you can to make it clear that you're not like the attorneys they've dealt with in the past is really important to building a relationship with your client. The other thing is these are inaccurate. I hear this one. I've had this given this presentation, had people say like, okay, well I'm gonna work with this felon on such and such. Not everybody who has a conviction has a felony. People have stuff on their records where they were not convicted, which I will talk about a little bit. They're not always convicts. They don't always spend time in jail. There's a variety of different reasons that people end up with convictions or stuff on their background check that needs help to get removed. So I just try and stick with what I found the most accurate, which is people with convictions. The other one I'm going to talk about that I hear all the time is collateral consequences. This one's a pet peeve of mine. I beg you not to use this one, but I hear it a lot of times from defense attorneys, especially prosecutors. The idea of collateral consequences is, somebody gets convicted of a crime and maybe they spend a day in jail and they get a conviction on their record and they get legal fines. A lot of times that's considered like, okay, this is their sentence, is whatever is on that judgment sentence. But if they end up owing $700 in legal fines and those get sent to a collection agency and it damages their credit report or their credit score, those are talked about as collateral consequences. If they can't get a job because they have a record, those are collateral consequences. And there's a lot of discussion about that kind of in the field. One of the reasons I hate this term, and I ask people not to use it, is for your client, for somebody who has a conviction, there's nothing collateral about these consequences. These are just the natural progression of what happens. If you owe money, your credit score goes down, and it doesn't matter if the reason you owe money is because of a conviction or not. I also don't think, that one of the ways of framing it as collateral consequences is that this is like incidental. But I don't think anybody is surprised that if you owe money, your credit score goes down, or that if you have a conviction, it is harder to get jobs. It's not incidental. That is the consequence of having a conviction on your record. So I tell people, like, from the point of view of the person who has this conviction, they're not collateral. And it shouldn't be a surprise to anyone who does any work in this area that this is just naturally what happens when you have a conviction. So I just tell folks, they're just consequences. They're just parts of the sentence, whether they're intentional or not. We know that that's true. And the last thing, the legal vocab for today is talking about the difference between vacating, expungement, and sealing. This is important because if you're going to talk to somebody about this, and I say to anybody about this, these terms are really confusing and they are a mess, especially in Washington State. If you do a Google search and look up, I want to get something off my record, you will hear vacating, expungement, sealing, deleting. There's a couple other ones, and they're used interchangeably. And there's a reason for that, which is that in most of the other states, they are interchangeable. They're synonyms. In Washington State, these are very different legal acts, and they have very different meanings. So in Washington State, and as far as I've seen so far, only in Washington State, vacating is the thing that you're probably going to want to do for someone. What vacating means is you are getting a court order that removes a record of a conviction from the Washington State Patrol background check report. This is basically the publicly available criminal background check. There are a lot of private companies that pull their background check information directly from the Washington State Patrol report. It's called a watch report. And I'll show you what a watch report looks like a little later in this presentation. When you vacate something, that order does essentially two things. One is it tells State Patrol, it does three things. It tells State Patrol, take this record off the watch report. It's no longer visible publicly. Number two, if the person pled guilty or there's a guilty charge on that case, the court changes it to not guilty. And third, and probably most importantly, it gives the client who has the conviction vacated the legal right to tell people they don't have a conviction. They're allowed legally to answer the question, were you convicted of this crime? They can say no, which is important for employers. Now, this is basically for 99% of the clients that I see, this is what they want and what they need. There is a process in other states where they refer to it as expungement, which is very similar. It's kind of the same thing. In Washington State, we do have something called expungement, but all that expungement does is it is a form process for asking State Patrol to remove what they call non-conviction records. But what really looks like are mistakes on their watch report. So if you have someone who was arrested for possession of marijuana, but oops, it was a mistake, nothing happened, they're charged, but then they're released and the charge is dismissed, that sometimes will show up on someone's State Patrol report, on their watch report, for that, especially for that period of time where the charges are pending. And State Patrol doesn't always get the notice from the court to remove those. They also have there's also a period of time where they're allowed to just leave this stuff on someone's record. If there's been a mistake and that stuff hangs out for years and years, there is a form to have that expunged, which is not a court process. It is essentially a letter to the State Patrol saying, hey, you made a mistake, can you please fix it? They consider that non-conviction data. There's a lot of tricky stuff about this, and I'll mention it a little later, but for most people, all expungement means in Washington State is fix a mistake on your State Patrol report, and that just doesn't happen very often. The Washington State Patrol is pretty careful about only leaving stuff on people's background checks that at least they believe are important to be on there. And then finally, there's sealing, which is a court process where you ask the court to essentially make a document or the whole court record unavailable to the public, full stop. This is the only way to make documents inaccessible to the public. Now, depending on what county you're in, this might be something that is very commonplace. I can tell you in King County, almost none of the courts seal anything. There is a constitutional balancing test, and at least in King County, the public's right to have information is almost always deemed paramount, except in there's the risk of violence in like a domestic violence case. Sometimes I've seen stuff sealed. I know that there are counties in Washington State where sealing is more accessible, and that can be really helpful. Probably my first tip to anybody who is in a county where that is possible or might be, you really need to vacate and seal the record, because I have certainly seen situations where a court record is sealed, but the court order does not vacate that conviction as well. And Washington State Patrol never hears about it. So it's a sealed record, but Washington State Patrol still shares it publicly. Most of the time I've seen sealing is not accessible to people because there's such a higher level of scrutiny by the judges. But if this is if you're in a location where the judges are open to sealing records, it's great. You want to seal and vacate, that pretty much just removes that record from any sort of public access, full stop. So I'm going to tell you a little bit before we go into the process of vacating, why it's valuable, kind of what a conviction looks like, what a typical case might look like for you, what a typical client situation looks like. A lot of folks, I think, if they haven't experienced this or been involved before, might have misconceptions about this. So here's an example. I have two client hypotheticals I'm going to share with you. Both of them are based on former clients that I have served. These were folks that came in through the King County Bar Association's program where I used to work, but it's very common statewide. So with client hypothetical, Judy, 1978, she is convicted of possession of stolen property. That is a felony. I think it was a Class C felony, the lowest level of felony. She was employed through DSHS at the time she got this felony and continued to be employed. They didn't fire her because of this record. Then and I want to say this is probably maybe 2017, 2018 was when she contacted my office. She went on temporary unemployment due to injury. She was injured. She went on temporary unemployment. She got better. She finished her medical work. Now she needs to find employment again, and she can't because she has a conviction on her record. Now, this is a woman who's been employed consistently since 1978 at DSHS. That never impacted her employment while she worked there, but the moment she went on unemployment, now she can't get a job. So vacating that possession of stolen property from 1978 was a necessity, essentially, for her to find employment at the level at which she was working before. And we were able to vacate that fairly easily and get her back get her back to work. I'll show you another client hypothetical. This is also a very common situation, folks, type of folks we'd see. We have Amanda. She is a single mom. She had 3 children, ages 10, 5, and 3. This is a few years ago, so probably older. They're a few years older now. She also has the 5-year-old is a relative's child that she was in the process of adopting. She had 20 convictions for no valid operator's license. And this is really super common. These were all like mid-90s convictions. They're all basically over the course of a few years. So she'd get a conviction basically every month. The way that this had happened is in 1994, she had a conviction for theft in the 3rd degree, which I believe was a gross misdemeanor. So fairly low level charge. But as a result of that, she had fines that she needed to pay off. And Amanda had some traffic tickets as well. And she was paying off her legal fines, but wasn't able to pay off the traffic tickets, and her license was suspended. Well, she has 3 kids, and she needed to drive, I think at that time it was probably oldest, to daycare, and she would get arrested, or she would get pulled over and charged basically every month on her way to childcare. And this happened 20 times. She didn't have the option to not drive a car. And as a result, she has 20 convictions for no valid driving without an operator's license. The punishment for that, by the way, is a fine. So she's got these stacking fines. She has a theft in the 3rd degree, and then in 2004, she has a marijuana possession less than or equal to 40 grams, which at the time was illegal, but no longer is, or no longer criminalized. Because of this extremely lengthy criminal record now, she was unable to find employment or housing. I believe her and her 3 kids were staying with a relative when she contacted us. Vacating these convictions was going to be a huge amount of work because there are so many of them, but also what a giant difference this is going to make in her life. And I use both these hypotheticals because this is super common, both of these situations. Talking about people who have never posed a danger to anyone, and who largely these crimes are property or financial in nature, but suddenly they're not able to get a job, they're not able to find housing. This stuff can tie people's lives up. I mean, for both these people for 20, 30 years, longer. So that is why vacating convictions and doing this work is so important. And I'll talk a little bit later about why it's so important to have a volunteer attorney involved. I'm going to talk about how conviction becomes a barrier, and then I'm going to do take a very short break after that just to look at the questions, if there are questions in the chat. So I've shown you kind of what convictions look like, a hypothetical client, and how that has impacted their lives. But I want to show you what the sort of legal process of that is like as well. So I mentioned before that vacating a conviction, one of the main purposes of that is to remove that record from a publicly available background check report. The Washington State Patrol shares this. It's called a watch report. You can right now go on State Patrol's website and pay, I think it's $12. If you enter somebody's name and their date of birth, it will spit out a background check that looks just like this. If they have any sort of convictions on their record, it will look something like this as well. So this is a redacted and watch report from a real person, but this is what they'll look like. And if you end up helping a client, you'll see one of these in their file. Here's this person. The first page shows date of birth. There's a space here for their name, their sex, their race. Here on the second page, there's demographic information, and then here's the section that says conviction and/or adverse finding summary. This person has one felony conviction, assault in the 3rd degree. It's a Class C felony, and then a little spot here for disposition date. I always tell people, so the disposition date is some number that State Patrol pulls out of a database somewhere. Sometimes it's the date someone's convicted. Sometimes the date it's filed. Sometimes it's the date of judgment sentence. It's somewhere within a year generally of an event in the case early on, but is rarely accurate enough to tell you a whole lot. Then on the second and third page, you have this section over here, which sometimes includes details about the case, the date of arrest, where this, who is the arresting agency. Here's Seattle Police Department. You can see this is in King County Superior Court, assault in the 3rd degree, the RCW that was cited, the status date, which is again, maybe or maybe not accurate about when this person was convicted. And sometimes it'll include sentence information like this. One count, this person was sentenced to 4 days in jail with 12 months of community custody. This person spent a few days in jail and then they were on probation for a while. This information that shows up here gets pulled into a variety of private background check companies. They pull this information, I don't know how regularly, but probably every month or so. But if you did a search and paid $20 to look up somebody's record, this is probably where that information comes from. And that looks like this. So this is a different client who was applying for a job at Uber. Now, the thing is, for most people, they're never going to actually see this. They're just not going to get a call back after they interview for a job or after they apply for a job. I believe that they're supposed to find, you have a right to find out if somebody does a check on you. But most people just never find out. You never hear this. Most of my clients, when they come, it's hey, you said you have a conviction on your record. Has that impacted your ability to get work or housing? And most of them will say, like, I think so. I assume I have a record and I don't get calls back for the jobs I'm applying for. But most people, they're not going to know one way or the other. This one was interesting if somebody actually got the report back. So I'm able to show you what that looks like. From a company called Checker, you can see that Uber was the one who requested it, and their status for this person is consider. And then on the second page, it says, okay, consider that the National Criminal Search and the County Criminal Searches both showed up something. And essentially for most employers, if they have a competitive field, this is just, we're not going to hire you. Something came up at all. It has nothing to do with what that is. It has little to do with whether it's accurate or not. At this point, you're probably just not getting that job, which is why vacating can be so important. So I'm going to take a real quick moment here just to look in the chat and see if we've got any questions for me. If I can figure out how to do this, I think I have to stop share. So I'm going to answer a couple questions and then jump back on here. Here's a question for the end, so I'll save that for the end. In my experience, is it easier to seal records in Kitsap County than in King? You know, I don't know. I have done very little work in Kitsap County. Most of my work has been in King, and I don't have the answer about sealing records. So I think maybe at the end I will ask whether Joanne has any advice on that, but I'm not sure. Here's another person asking about sealing. I've had a client in, I'm trying to remember which county she was in. Might have been Pierce County. No, I'm sorry. It's Walla Walla, where they filed a motion in order to vacate and seal the record, and the judge signed it. And this is not a person where they were in like a really difficult. There's no violence alleged. This was just a, hey, you know, this thing's popping up on my record and it's a problem. The judges were able to sign that. I've heard that from a few different attorneys I've worked with, that their counties, I think most of them were in Eastern Washington, but who basically said, in my small county, the judges are willing to seal records because they understand that these can pose barriers to people even after they're vacated. Are you asking about GR15 sealing? I think so. There's another question about, are there any typical felony cases which the courts do not approve of the motion to vacate? I'll talk about that in just a second. Let me share my screen again. Okay. But I'm going to make a note about the felony question, so make sure that gets answered. And then I will check back in. I have a Q&A section at the end, so I'll answer another round of questions when we get there, and I'll make sure we've saved some time. So what is my program? What is the Rantry Legal Aid Program? So we do a few different things. This is a new legal aid program. Civil Survival is a nonprofit that is run by and for formerly incarcerated folks. They were originally their own nonprofit, but they have since joined the Public Defenders Association, so I'm part of a much bigger office. I myself am not formerly incarcerated, but they hired me on because I did a lot of the same work at the King County Bar Association for a few years. And last year, they received a grant to do legal aid. So prior to this, they worked on policy, they worked on community organizing, and that is a major part of the work that Civil Survival does. They also want to be able to provide direct legal aid to their clients, to the people they serve. And so me and another staff attorney were both hired to do this work statewide across Washington. So what I do is I recruit volunteer attorneys. I mentor volunteer attorneys. I answer questions about how to do what the legal process looks like. I work with court personnel and judges to try and make the processes easier for both attorneys and for people representing themselves. Do a lot of vacating. I directly represent clients, usually folks who have really difficult cases or situations that aren't so clear. And I do a lot of case research, training volunteers. This is a relatively new program, so I've only been here for I think 7 months. But this is an expansion of the work I've been doing in the past. And I'll tell you, 2021 looks like recruiting for me is my main goal. I'm trying to get as many volunteers as I can anywhere in the state who are willing to take these cases on, because they are actually quite easy to do, but are also procedurally complicated enough that is very difficult for someone to represent themselves and be successful. And I try to make this process as easy and fast for attorneys as possible because I've been doing this a while, so I know some tricks to vacating, to looking at people's records, to getting the information you need. But there's another reason I say at the end I'll have my email address. Do reach out to me with any questions. Pass it along to other people who want to volunteer or just have questions about this work. My goal is to just bring the level of knowledge up about reentry. So let me show you what the actual legal process looks like. So here's the tricky part. Then this is the trickiest part for people representing themselves too, is only some convictions are eligible to be vacated. And there is a handful of different requirements that seem simple. And then as soon as you start looking at people's actual experiences, what their actual records look like, becomes a mess. And I'll talk a little bit about why that is. So here's what makes a conviction eligible. These are the general rules. They're not applicable every time, but here's what it looks like. Only certain types of convictions are eligible to be vacated. If it is a sexually related crime, if it is a violent crime, if it involved a weapon and it was a violent crime, if it's a DUI, generally speaking, those are not going to be eligible to be vacated. Just under the statute, there's a few different classes of convictions that are not eligible. There's the laws on this were expanded. The eligibility was expanded in 2018, and there are some laws being considered right now by the current legislative session that may expand it again. So there's things are always a little bit in flux, but those are the general rules. I'll talk a little bit more about that in specifics here in a second. The person needs to have most or all of the obligations for that sentence complete. So, for example, somebody gets convicted of reckless driving. They spend a night in jail. They have a year of probation. They have to do 20 hours of community service, and they owe $800 in fines. Until all of those obligations are complete, they are not going to be eligible, with the one caveat of the money fine sometimes can be, there's some work that you can do to sometimes make someone eligible, even if they still owe money. But across the board, that person needs to have done their community service. The year of probation needs to have passed. They can't currently be in jail for that conviction. Now you're looking on this, by the way, you're looking at this at conviction by conviction. If somebody has 20 convictions, 18 of them might be eligible and 2 of them are ineligible. You have to do this sort of eligibility review for each one individually. Generally speaking, they need to have all their fines paid, but one thing I'll mention is a lot of people are eligible to have their fines waived. People who are low income, people who are considered legally indigent are eligible to have their fines waived. They probably don't know it. So a lot of my clients, a lot of folks who come through my program, we're going to ask to waive your fines and vacate the convictions, usually at the same time, because as soon as they're waived, then they're eligible. There needs to have been a certain number of years passed since completion of these obligations. This one also has a little twist because they always do. The general rule is if it's a Class B felony, which is the most serious level of felony that is ever eligible, 10 years needs to have passed. For Class C felonies, 5 years needs to have passed, and for misdemeanors and gross misdemeanors, 3 years. There are a couple things that sometimes extend those timelines, like if somebody has multiple DUIs that have been amended to reckless drivings, or somebody who has multiple domestic violence related convictions, sometimes there's rules that sometimes move those years out a little bit. And if a really common situation is somebody has completed all their obligations except they can't pay off their fines because they're too poor to pay $800, but it's been 10 years since their conviction. There are a lot of circumstances where getting those fines waived will make someone eligible backdated to when their other obligations were complete. So as sort of a general rule, the one takeaway from this is if somebody is 10 years out from their conviction, has never run into any other problems, but they still owe money, they might still be eligible to vacate. That requires kind of a second look. If there's anything other than fines still hanging out there, they're not going to be eligible. Person can't have any recent convictions or pending charges. So what, for example, like I said, you need, for a Class B felony, 10 years needs to have passed since they've completed all their obligations. There's another rule that says they can't have any convictions in the past 10 years. So they also need that amount of time of a clean record. For misdemeanors, it's 3 years. For Class C felonies, it's 5 years. Most of the time what this means is if somebody's got something pending, if they've got some recent conviction, they're probably not going to be eligible for anything. But once 3 years have passed and they don't have any records, suddenly misdemeanors are eligible. 5 years, now you're looking at Class C's. Usually you can kind of look at somebody's record, look at their watch report, and get a really quick sense of whether things may or may not be eligible. And lastly, they can't have any active restraining orders or open warrants or any sort of active pending court orders. This usually isn't an issue because most folks who have like an open warrant or a restraining order probably know it. One time this gets a little weird, and this is another goofy spot of the law, is if somebody has an anti-harassment order against them, they're not eligible to vacate anything. I've had a few clients come through where it's like, oh, my neighbor and I don't get along. They got an anti-harassment restraining order against me, so I can't vacate my 20-year-old possession of marijuana charge. That's true. And unfortunately, there's, as far as I've found, no way around that one. I've had folks where they had a domestic violence restraining order of an unlimited duration. The victim in that case had moved away 20 years ago to another state. That person's just not eligible. They have to get that order lifted before they're eligible to vacate anything at all. Let me tell you what the timeline of these look like. Now, I know Joanne has been doing this work, so this is what I would say most courts look like. This may not be the case, especially in the bigger courts. So here's what the timeline looks like. Let's say, imagine you're trying to help somebody vacate a conviction through my program, and they have a conviction in Redmond Municipal Court. You're gonna get that case, get the case file that has a watch report, has a copy of the background check, lists out what their convictions are, whatever we can find from the court dockets. Maybe we'll find a copy of the judgment sentence on their convictions. You're gonna meet with that client, you review the file, ask your questions, meet with the client. You're gonna draft the paperwork, which I'm gonna show here in a minute, communicate with the prosecutor. Paperwork is very simple. It's a form you fill out. You file it with the court, and then here's the actual work in most of these cases. You wait a month with COVID, maybe 2 months, maybe 3 months. The real work I've found in these cases is bugging the court and bugging the prosecutor, because in my experience, the reason that this process is not accessible to people representing themselves is these cases fall through the cracks basically the moment they leave your hands. These are the lowest priority, almost across the board, with a few good courts where either a judge or a prosecutor has seen the value in it and has made a process that works. Now, the reason for that, at least in my opinion, is these are weird motions. You are asking a court to vacate a conviction that may be 30 years old. So that case file has been closed for 20 years, maybe 30 years. And a lot of times those case files are then deleted. I've definitely had folks where there just isn't a case file anymore. It doesn't exist. It's an old enough conviction. And the motion you're making looks an awful lot like a civil motion, because you're asking a court to basically review the file and close it out and then send a copy of the order to State Patrol. And those are very hard for some courts that don't see them very often to even figure out how to docket them. Do they go on the criminal motions calendar? It's an old case. Does the client need to show up in court? Does the defendant need to be there? Doesn't seem like they need to be, but maybe the criminal law process there requires it. these get very weird, and they tend to fall through the cracks if they don't have an attorney or a paralegal calling once a week saying, okay, have you set a hearing? What do I need to do? What's the next step? Did you actually move this on to the next thing? Because they're easy to forget about. I use this as an example because this was always funny to me. I had an early case, when I first started doing this work. I was just directly representing everybody because I wanted to know how to do it. We didn't have any volunteers then. I had a client who had some minor conviction. I think it might have been driving without an operating license from Seattle Municipal Court. Met with the client, drafted the paperwork, called the court and was like, can I, should I talk with the prosecutor? What do I need to do? And they basically said, no, you file it and we send it over. No problem. So I filed it. Seattle Municipal Court, waited a week, didn't see anything, didn't hear anything. So I called the court clerk and I said, hey, I filed this motion to vacate. Here's the case number. Here's the client's name. Can you look in and see what happened? Because I just haven't heard. Do I need to set a hearing? What do I need to do? And the clerk looked and went, oh, yeah, I'm glad you called because this case, when you file a case electronically in Seattle Municipal Court, they get filed with the same courtroom and same judge as the other motions in this case. But this case is from 20 years ago, so it went to an empty courtroom and to a judge who's retired, and it just was going to just sit in that queue indefinitely. So I'm glad you called. Let me just move this over to a place that will actually get heard. That is not uncommon at all. I've seen 1,000 different weird situations, different weird processes. Comes up all the time. So that is why somebody representing themselves who may have a harder time getting a prosecutor on the phone or getting in touch with the judge's bailiff or know how to ask the right question, this process is going to be totally inaccessible to them, even though the actual legal paperwork you fill out is pretty straightforward. Let me show you. So I talked about this meeting with your client. I'm going to speed through this because hopefully you're going to volunteer with Joanne's program after this, and she can walk you through what you need for that. But I'll tell you really quickly, when I have volunteers for my program, you want to meet with that client. You want to have them fill out a representation agreement. Makes it very clear that you're helping them with vacating this particular conviction, but you're not their criminal law attorney for anything else that might happen. You really need to develop rapport and compassion. I mean, this is common. This is just legal skills across the board. But I do want to say you will have a much easier time with this if you're, for example, have a relationship with your client where they feel comfortable calling you a week later to say, oh, I just got arrested, so there's no reason for you to vacate. Now I have an active case, so you should stop. Adapt to your client's circumstance. Here's the other thing. Somebody may have 20 convictions on their record, and you may look at that record and go, oh, they have this Class B felony assault from 2001 and a bunch of nonsense driving with license suspended convictions from a long time ago. So I know this is the serious one. I need to get rid of this felony. Client's actually going to know which of their convictions is bothering them and which one actually comes up when they apply for a job or apply for housing. It may not be the most serious one. The way that background check companies pull that information from state patrol, the way that information is disseminated can get really weird. The client's going to know, and you should follow their direction as to where to start. Ideally, you vacate everything you can, and this puts them on the best possible footing, but take their direction. And trust them that they'll know what's been messing with their life, because it's not always going to be what's most obvious to you looking at the record now. So let me show you what the misdemeanor vacating form looks like. And I will tell you from talking with a handful of prosecutors, I don't know if this is true in every case, but I can say with 100% of the prosecutors I've talked to, they say, use the form, make this as simple as possible for me. I don't want to have to look at anything. Don't add an extra declaration or brief if you really don't need to. Here's what the misdemeanor vacating form looks like. This is on the Washington Court Forms website. Very simple. The motion is 1 paragraph long. We're moving to vacate this. And then there's a declaration section for the defendant that says, I was convicted on this date of this offense. And then a series of checkboxes you can see over here. And all these checkboxes are here are things that would make you ineligible. Is your conviction you're asking to vacate a sex offense? Is it a violent offense? If it is, you're not eligible. Here's a section about prior offenses, which is a terrible term that the state uses to describe DUIs that have been amended to reckless driving. Pretty much only that one circumstance. If you have a DUI that's been amended to reckless driving, there's additional requirements. But this is basically fill out these check boxes. If you checked enough of these boxes, you're not eligible. It should take you 10 minutes to fill out this form. There is an associated proposed order form as well. Looks almost identical. It's fill out the same check boxes over again. Here's what you need to file in order to vacate a misdemeanor. You need your notice of appearance. You need a motion and declaration to vacate, that form I just showed you. The order on a motion to vacate a misdemeanor conviction. It's a court form that looks almost identical to the one I just showed you. And depending on the court, you need to set a hearing or note up a motion. Some courts don't even require you to do that. My number one advice is file the paperwork and then call the prosecutor and say, can you agree to this? Can we just put this in front of a bailiff? Most of the prosecutors I've worked with have no interest in fighting these motions unless the person has a really violent domestic violence related history. And very few of those cases are going to be a situation where someone's eligible. Basically, the eligibility requirements are so narrow that 99.9% of the clients are only going to be eligible if it's some minor offense that was from a long time ago. And my experience is prosecutors really don't have stake in the game to fight those. It's not worth their time. So agreed motions are usually pretty easy to come by, and then you can sometimes just hand those to the judge's bailiff and say, hey, this is all agreed, would you sign it? Often you don't need a hearing for these. For felonies, things have one little twist to it. Paperwork looks the same for felonies, by the way. There's a few different check boxes, but you're going to see mostly the same thing.
All right, so we have lost Jacob, and we are trying to get him back. So he must have had some sort of weird internet glitch on his end. So we will wait for him to get back. But while we're waiting for him, I guess I'll do my little spiel that I was going to do at the end. Oh, there he is. Good.
I'm very sorry about that. My computer crashed mid-presentation. Just keeping the excitement for everyone. All right. I'm just going to pick up right where I left off real quick because we're almost at the end here. Again, sorry about the technical issues. Quick. Okay. So, as I was saying, for felonies, there's one twist to this. You want that same motion and declaration. There's a felony form. Looks very similar to the misdemeanor form. There's a proposed order form. The difference is for felonies, in order to show somebody's completed all their obligations, the court actually enters a certificate of discharge. And most people do not get one automatically provided by the court. So there is a separate set of motion, a different motion and order that basically says, this person's completed all their obligations. Please provide a certificate of discharge. And here's the proof that I've done it. Usually for me, the proof is, here's a copy of the court docket that shows 20 years ago, you closed this case because they completed all their obligations. That just means there's 2 extra pieces of paper that you need to do for a felony. Now, I will say, these motions to vacate are attached to the original case number, which means if someone has 15 driving with no operator's license from Seattle Municipal Court, I have to fill out this paperwork 15 times, one for each case number. It's a very messy way to do this, but each of those motions needs to be heard and filed with the original case to basically close out that process. Filing and serving. Procedures vary by court. You can probably ignore the stuff about King County, but feel free to email me. I don't know all the courts because there's plenty of places I have not practiced in, but I'm happy to help you find out. And there have been a handful of places where we do have my office has relationships with the prosecutors of the courts. One thing that is worth knowing, no formal service is necessary because you are filing a motion on an existing case. You're not filing a new case. There's no service because the person you're serving is the prosecutor. So what you need to do is mail them a copy. But usually what I do is call them and send them an email because they don't usually want the extra paperwork. This should be very simple. If you are one of those lucky few who files in a court and the court says, okay, we'd like your $200 filing fee, give me a call or an email. I have found a few courts that have tried to do that, and usually a sternly worded letter reminds them that you're not filing a new case and they should not be charging people for this process. After the order, if you get an order signed by the judge vacating this conviction, you should notify Washington State Patrol. The court is supposed to do this, but I like to do it just in case. State Patrol has a records department email address. I just email a copy and say, hey, we got this order signed, here you go. Verify the court records are updated. Usually within a week, it'll show up in the court docket, usually shorter. And Washington State Patrol has like I said, they have a records department that handles this, who I found is actually very friendly. If you call them and say, here's my case number, I sent you it was vacated a week ago. Can you check? I've had them check to see when it's vacated, if it's not, how long it'll be, and they'll often check the FBI databases as well to see when the information's been shared out. And then if somebody has multiple convictions, you start on the next one. There's nothing stopping you from doing multiple ones at the same time. These don't have to be sequential. If somebody's got 6 different convictions, you can file 6 different motions and orders at the same time. But my advice is try and get them all vacated if you can. Last, here's a couple tips. Ask to vacate multiple subsequent convictions. I'm not sure subsequent's the right word. Multiple convictions in the same court, file them at the same time. You may see somebody who has 5 convictions in, I don't know, Seattle Municipal Court, and you may think, okay, I'm going to draft all the paperwork, file it. Well, that one's pending. I'll draft all the paperwork for the next one and file that. Don't do that. Wait, file all 5 at the same time, even if it takes you longer to do all the paperwork, because the prosecutor and the judge are both going to have to review that client's file to see if they're eligible. And if you file it all at once, they only need to do that once. And if you're going to have a hearing, that means they can schedule one hearing to review all these cases. If you spread them out, it's just going to give everybody a headache, and they'll be less likely to probably agree to your motions and give you a break. The last one, and this one's really messy, deferred convictions. So super common situation, somebody is arrested and charged. They're offered a plea agreement to plead guilty and do X, Y, and Z, and then we will take this case off your record. Or maybe it's, you don't have to plead guilty, but if you don't have any convictions within 6 months, then we'll wipe this out. If somebody pleads guilty as part of their plea agreement, that guilty plea goes to State Patrol and ends up on their watch report. And you may end up in a situation later where you go to the court and say, hey, this thing's showing up on my client's watch report. I'd like to vacate it. And a judge will say, well, there's nothing to vacate. I dismissed this case. They're never convicted. There is case law in Washington State that clarifies that you can still vacate something even if it was dismissed. Basically, you can vacate stuff that shows up on somebody's watch report, no matter how it got there. But that is a more complicated argument you may have to make to a judge who just does not realize that even though this case is dismissed and the plea agreement looks normal and everything seems normal, Washington State Patrol doesn't care. And if it shows up on someone's record as a guilty, it's going to stay that way. Sometimes what they'll say, what'll show up on someone's watch report is convicted of assault, dismissed, pled guilty. The way that ends up in an employer's hands is this person is guilty of assault, and it doesn't matter what the court record shows because they never look at it. If you end up in this situation, feel free to email me. It does happen. I have briefing that you can give a judge to show them, look, this is an answered question, but it can get tricky. I've also seen judges who look at it and go, no problem, vacated. But that's another one where there's a lot of discretion there. Lastly, if you've seen this presentation, you pretty much have all the tools you need to do this work. It is very form heavy. The biggest part of this is just reminding the prosecutor and the clerk and everybody to just keep the process rolling. But we always need volunteers. There's hundreds of thousands of people who have convictions eligible to be vacated, and there aren't that many attorneys doing this work. There aren't that many folks who know this work. As far as I know, there's only a handful of legal aid programs even doing this. So if you're interested, take a case. It really, truly changes someone's life to be able to get a job when they couldn't before, or get an apartment when they couldn't before. And that's what this does. And last, sorry about that interruption, but we have a few minutes for questions. My email address is here, jacob.kuykendall@defender.org. Again, if you have any questions, if you want briefs or whatever, I'm happy to share whatever I've got with you. Hey, Joanne.
Hey. So do you want to answer questions first?
Yeah, absolutely. If we've got some time.
Okay, yeah. So I think the first question that you didn't, well, there was one that said to save to the end. That was at 12:13.
I'm going to stop sharing, but I will put my email address in the chat for everybody. Okay. Well, I have lost the chat because my computer crashed. Would you mind reading the questions to me?
Absolutely. So question from earlier was, some of my colleagues asked me today if someone can have a sealed juvenile vacated. I'm assuming a sealed juvenile record. In other words, vacating after sealing. I say no. Am I wrong?
I believe, so as a general answer, I believe you can vacate after something's sealed. It's really messy because I think maybe you'd have to have the court unseal it, vacate it, and seal it again. I don't think you can seal juvenile records. At least I've never heard of it happening. I am a little unclear. I'm not sure why you would need to, so it wouldn't surprise me if there's some messy situation that somebody's in, but I don't think so. You can definitely, yes, you can definitely seal juvenile records. Whether you can vacate a sealed juvenile record, not sure.
All right, another question is specific about Kitsap County. It just says, FYI, I had Pro Tem Tim Drury refuse to seal a dismissed felony diversion in district court under the impression that he incorporated advice and policy from Judge Kelly, who was presiding then. So not really a question, just a comment.
Yeah, I mean, I don't have much more to say to that except, yeah, I've had trouble. I've never been able to successfully seal anything in King County, but I have heard other counties are different. So I couldn't answer for Kitsap, but it doesn't surprise me to hear that.
Yeah. Okay. Next question. WSP had me email crimhiss@wsp.wa.gov after successful sealing in Chelan County, but not updated on WSP. Do you know the effect of this?
If that thing is still on the person's watch report, it's going to show up on background checks. And I will say, as much as I think that State Patrol, when I've called them, are very friendly, their position as a policy matter is they will not remove anything that they're not required to remove. My intuition is this is for liability reasons. They do not want to remove something and then show up on the news that they removed something and now that person's got a job and they've committed a crime or whatever. But if they don't see a court order and they're not required to remove it, they just won't. The expungement paperwork, if you look at it, it has a giant list of, will we remove this, yes or no? The answer is probably no. So you may need to help that. In order to help that client, you may need to vacate that conviction that has been sealed, probably need a court order of some kind.
Okay, and then the next one you sort of answered in your presentation. What is the typical time commitment for a single case?
For single case, I mean, it's going to vary a little bit on how many convictions someone has and how many you're able to work on or whatever. I usually say for your first case, expect maybe 10 to 15 hours spread over a month or two. It's kind of at your leisure. If you need to have a hearing, there's probably only going to be one hearing at the end. They get very fast from there, but the thing that's really going to take time is the check-ins. It shouldn't take you more than an hour to fill out paperwork. Shouldn't take you more than an hour to review someone's case, but you're going to be doing a lot of making sure everything just is moving forward.
All right, next question. Did you say you need certificates of discharge on misdemeanors, or did I misunderstand?
I don't know if you misunderstood or I misspoke, but no, you don't need certificate of discharges on misdemeanors. That is felony only. If in order to show a misdemeanor has all the obligations complete, you just need to have a declaration and have that show up in the docket somewhere. You just need to show it.
Any thoughts on bail forfeitures?
Not really. It has not impacted my work that much, except that it sometimes shows up as a weird thing on people's like jabs records, but it hasn't impacted, from what I've seen, anything for folks trying to do reentry issues.
Okay. Oh, and then I see, Jacob, you posted your email, but only to all.
Oh, to the panelists. Thank you.
But I will also put Jacob's email in the email I will send out after this presentation with other information. Didn't it used to be that you could only vacate one misdemeanor? Can you vacate as many misdemeanors as you want if they're not excluded?
Yes, that is correct. So prior to the New Hope Act in 2018, you could only vacate one misdemeanor. Now you can vacate any misdemeanors. You can vacate them in any order as long as they're eligible. You can vacate everybody's eligible convictions simultaneously if you'd like.
Okay, then someone said you definitely conceal juvenile records.
Yes.
Okay, and then is there something new on the Q&A?
Yes.
Can you see the Q&A?
I can see the Q&A.
Okay.
So I have a question that says, if someone has 20 different convictions and the time limits have all passed, so the convictions are eligible for vacating, how likely is it for a judge to vacate all those records? Isn't it based on the judge's discretion? I believe it is. I mean, ultimately, I believe most of this is up to the judge's discretion, but I would say very likely. Part of this is that does happen, that somebody has 20 convictions, but in order for those all to be eligible, you're talking about somebody who has 20 convictions from 5 or 10 years ago, who've paid off all their fines, who completed all their requirements of sentencing. And the argument against vacating those is, well, this person had a long record and it should stay there so nobody hires them. And I just don't think that argument carries water most places of the state anymore. You certainly do see that, I guess, occasionally, but I have good success with this.
So I didn't see any more questions in the chat, but I did want to make a comment. Kitsap Legal Services has not done this type of work yet, but I will say that we recently created a program for reducing legal financial obligations. And we worked with the clerk's office, we worked with the prosecutor's office, and we worked with the court. And the prosecutor, I mean, they're allowing us to just send things directly to the prosecutor's office, and they look it over, and then if they agree, they just sign off. And then the court has said, as long as the prosecutor's office signs off, the court will sign off. So then there's no court process involved in that. So our next thing that we're going to work on is getting this program up and running, and I'm expecting it to be fairly similar procedure. We can just have a quick, direct line to the prosecutor, and then, as long as people are willing to sign off, it's a super easy process.
Yeah, that's been my experience as well. I mean, I've done a lot of these in a bunch of different courts. The person who's going to give you the most trouble, if anyone's going to give you trouble, is the judge. The prosecutors, in my experience, either are supportive or it's like, hey, whatever. I rarely had them opposed. And the times where they have opposed, it is going to be clear. It's pretty clear that that's going to happen, because it's like, oh, this person's technically eligible, but what a messy, weird record they have. The judges are the ones who will look at the statute, and it won't be super clear what their options are. And that's where you're going to have to say, oh, here's why this is good.
So do you have any last comments, Jacob, before I do a little housekeeping here?
Volunteer with Joanne and volunteer with me. We could always use more volunteers. I promise I will make sure that that is as smooth and easy a process as possible.
All
But
right.
thank you for having me.
Yeah, so yes, thank you very much, Jacob. We really appreciate that. That was really helpful. So if you don't know, I am the real Joanne Sprague. I'm the executive director at Kitsap Legal Services. I feel like it's a little bit like, what's my line, where I guess this is for the old people out there, will the real Joanne Sprague please stand up? So this CLE has been approved for 1 credit. And then earlier today, I did send out some materials by email, which included those orders that Jacob was talking about. It included the new HOPE Act, which is the latest law with the most recent changes on this. And, like Jacob said, that might be changing soon. So those are included in that email, and I will send them out again in case you didn't get them. So later today, hopefully today, I will send out an evaluation. And the reason you always get those, if you didn't know, is that if a program asks for CLE credits, they are required by the WSBA to send out an evaluation. So that's why we do that. I know they're kind of a pain, but we do look at the feedback, and so we would appreciate that. It will also give you a Google form to sign in on so you can get your CLE credits. It'll be one of those forms where you can just type in your information, tab, hit tab, and it's automatically saved, and then you can close it. And then I will report everybody's CLEs, but you should also make notes so that you can also report them yourself. And I believe we did record this, so we will also send that out. And then Jacob, do you have any objection if we send out your PowerPoint?
No, please do.
Okay.
And if you, again, if you want more documents, I have plenty,
Yep.
plenty stuff to share.
All right, and so then we will go ahead and send that out also. So this is a little bit about our plug. So Kitsap Legal Services, for those that don't know, is a volunteer lawyer program, and we're a nonprofit. And there are 16 such programs across the state representing different areas. And some of those volunteer lawyer programs do represent several different counties. So all of us need your support. So while Jacob was pleading for you to volunteer with us, actually go ahead and volunteer with Civil Survival if you'd like, or with any of your local volunteer lawyer programs. We all need your help. And if you're not really interested in doing this particular subject matter, we also do family law and housing and wills and bankruptcy, all that stuff. So by giving of your time, you are helping the low-income community that are your neighbors. And so that's really important work. And we can't do the work that we do without all of you. And if you can't volunteer, please support your legal aid groups financially. While we do get some support, we don't get nearly enough to be the vibrant organizations that we really, really would like to be. So I would like to thank Jacob. It was excellent. He is really kind of the expert in this area. So if you want to, I suppose if you have paying clients, you can do that. But if you're doing legal aid, please reach out to Jacob, and he can help you out with any issues that you have. And yeah, and like I know at Kitsap Legal Services, we are creating this program, and I think most of the volunteer lawyer programs out are, because this is a new, area of emphasis for the volunteer lawyer programs and legal aid. So in order to do that, we need the attorneys. So that's kind of all I have. So thank you so much for participating today. I found it very interesting, and it does make it seem like it's a fairly easy process, which is great. So anything else from you, Jacob?
I just see a question in the chat about asking to share materials and recording with non-attorneys. You're certainly welcome to share anything I have. And if you go to our website, civilsurvival.org, we have at least a couple YouTube recordings of other trainings I've done for non-attorneys just up there. If this recording turned out despite my computer crashing, I'll probably put that up there too. But yeah, please do.
Yeah, and anything that I send out, you are welcome to share. This is not proprietary in any way. So yes, more people that know how to do it, the better it is.
Hear, hear.
All right. Well, thank you so much for attending, and we hope to have some more CLEs on similar subject matter with civil survival. So yeah. Thank you very much, Jacob. Really appreciate it. And thank you to everybody who attended. And if you have any questions about anything, just contact myself more for the housekeeping type things, and contact Jacob for more of the subject matter type things. So again, thank you, and have a great afternoon.
Thank you.